Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Jamie and Harris, decided May 26, 2026. Rivera, J. The issue in this appeal is whether the indictment charging defendant with murder in the second degree should be dismissed, pursuant to CPL 40.42, because defendant had previously pleaded guilty on a separate indictment to criminal possession of a firearm. Contrary to defendant's claim, the murder prosecution is not barred by CPL 40.42a because the two offenses were not part of the same criminal transaction, and the separate indictments here do not result in the type of multiple, successive, or harassing prosecutions that CPL 40.40 is intended to prohibit. Therefore, we affirm the appellate division order reinstating the indictment. 1. On November 21, 2021, police responded to multiple 911 calls involving a person experiencing a mental health episode. Upon arrival at the scene, the officers observed defendant Jamie and Harris naked, with her hands through the broken windows of the front door to a residential home. Subsequent investigation would reveal that defendant lived in this home with her elderly grandmother. Defendant was highly agitated and pleaded with the officers, "Don't shoot me." Officers explained that they were not going to shoot and tried to calm her. Defendant told the police that she had dragged her grandmother's dead body to the couch underneath the front window and claimed that someone had broken into the house and killed her while defendant was asleep. Officers approached the window and observed the corpse of an elderly woman with a sheet covering her body. Defendant refused to remove her hands from the shattered windows of the door. Officers obtained entry to the home and, once inside, assisted defendant with getting dressed, handcuffed her, and placed her in an ambulance, which took her to the hospital. Once inside the home, investigators observed that the body was cold to the touch and showing rigor mortis. During a sweep of the home for other victims, officers confirmed that no one else was on the premises and observed that the basement door was locked from the inside. The basement and upstairs were in disarray, broken glass was on the living room floor, and the two front windows were shattered. Officers also observed several weapons during their emergency sweep of the residence, and after obtaining a warrant, they recovered a silver revolver with a black handle near the front door under broken glass. Bullets, shotgun shells, a machete, and a baseball bat embedded with glass on the first floor, a semi-automatic pistol in the upstairs hallway, and a disassembled shotgun in one of the bedrooms on the second floor. Later that evening, at the hospital, defendant made conflicting statements to homicide detectives, at times identifying herself as the shooter, while at other times claiming that someone else had killed her grandmother so that she could die with dignity. For example, defendant stated that the various guns in the house belonged to her grandfather, who had passed away the previous summer, and she often played with them, including a silver revolver with a black handle. She had fired 2 shots from the revolver, one of which may have hit her grandmother. Her grandmother had an axe in her hand and was going to hit her when defendant fired the 2 shots. She may have shot her grandmother, but, as she repeated several times, she loved her grandmother and couldn't hurt her and wouldn't have done that. She didn't mean to shoot her grandmother, and she felt horrible if she killed her. Her grandmother had dementia, and she was happy when she thought her grandmother died in peace, but when she saw a bullet hole in her body, she thought someone shot her. She moved her grandmother's body after she found her dead, and she heard someone upstairs the night before, November 20, and thought they broke or snuck into the house and may have did a die with dignity on her grandmother. When pressed by detectives, defendant named one of her sisters and her mother as the possible shooter. Defendant was arrested and charged that same day with 2 counts of criminal possession of a firearm, Penal Law Section 265.01.b, 1, each for the revolver and pistol. Prosecutors continued their investigation in the months that followed. Based on the autopsy conducted on November 22, 2021, the medical examiner determined that defendant's grandmother died from a gunshot wound to the chest and declared the manner of death a homicide. Investigating officers spoke with witnesses in the neighborhood concerning the shooting and defendant's erratic behavior, as well as with defendant's relatives, who discussed her prior mental health episodes. A DNA analysis report issued by the Police Forensic Laboratory on January 13, 2022, identified 3 contributors from the samples taken from the 3 firearms recovered at the house, at least 1 male and the other 2 female. The report concluded that defendant's grandmother was likely one of the contributors to the DNA found on the revolver, but excluded her as a contributor to the DNA found on the other firearms. On March 22, 2022, the prosecution presented evidence to a grand jury in support of the 2 simple possession charges for the revolver and pistol under theories of both actual and constructive possession. The evidence included testimony and footage from one officer's body-worn camera capturing the officer's approach and entry into the home. With respect to the homicide, the prosecution instructed the grand jury as follows. You also heard evidence of a homicide. That evidence was offered for how it may or may not, in your judgment, bear on the issue of possession and whether or not Jamie Harris possessed or otherwise exercised dominion or control over the guns found at the residence. It may not be considered for any propensity or anything else other than how it may or may not bear on your evaluation of possession. The grand jury indicted defendant on both firearm possession counts. On June 27, 2022, the prosecution received a firearms analysis report from the Police Forensic Laboratory, which indicated that the silver revolver fired the fatal bullet. On November 2, 2022, the date of a scheduled Huntley hearing to determine the admissibility of defendant's November 21, 2021 statements to law enforcement, defendant pleaded guilty as charged without a negotiated plea agreement. Prior to the plea colloquy, the prosecutor and defense counsel had a very lengthy discussion, off the record, regarding the effect of the plea on a potential future indictment of defendant for her grandmother's murder. The prosecutor described that discussion as follows. Part of that discussion entailed whether or not a plea in this circumstance would foreclose a further prosecution of an unindicted homicide charge. The conduct for which she was indicted on November 21, 2021, consisted of allegations of simple possession of a firearm. However, part of that investigation also covered the discovery of her grandmother's body, which was deceased, and the cause of death was determined to be a single gunshot wound to her chest. As I said, we had a very lengthy discussion about that, and whether or not this is a case, and these are circumstances that would bar subsequent prosecution for a homicide-related offense. Significant to that is the statutory language that exempts subsequent prosecutions where the evidence relied on was either non-existent or unascertained at the time of the initial indictment. Of significance, subsequent to the indictment, subsequent to the charges of these 2 possessory offenses, the people developed ballistic evidence that matched a slug recovered from the wall that we believe to be the slug that caused her grandmother's death. The prosecution then stated that it had no objection to the colloquy prepared by the court to address the possible future prosecution. Defense counsel also confirmed he and his client were amenable to the drafted colloquy. The colloquy as written is fine with us, Your Honor. We have had a chance to go over it. It has all been issues, facts that have been discussed as we have approached and made this decision. The court also confirmed defendant's understanding of a potential murder prosecution against her. The court, Ms. Harris, do you understand that if we went forward with the Huntley hearings and I ruled in your favor, the people would not be able to use those statements or the evidence obtained from your home against you at a trial? Yes. The court, all right. And you understand that the plea that you're about to enter and the statements that you will make with regard to this plea, that those could be used against you at a subsequent trial? Yes. And you understand that your plea of guilty today may not stop the police or the prosecutors from charging you with other crimes that could be related to the charge you're pleading guilty to today? Yes. The court. You understand that based on the conversations I have had with the people and with your attorney, that one of the crimes that they may charge you with is murder? Yes. The court. Do you understand that what you say today could be used against you in that later prosecution? Yes. The court. Do you understand that your plea of guilty today to possession of a firearm could be used against you if the people or the police choose to prosecute you for murder or some other crime? Yes. Defendant then pleaded guilty to both counts of the possession indictment. On March 13, 2023, the prosecution successfully sought permission to collect a buccal swab DNA sample from defendant. The DNA comparative analysis conducted on April 11, 2023, comparing defendant's DNA against samples collected from the revolver, provided what the prosecution described as very strong scientific support that defendant was a contributor to the DNA found on that weapon. On May 2, 2023, the prosecution presented evidence to a second grand jury charging defendant with murder in the second degree. The evidence included testimony from the same officers that testified before the first grand jury, each of whom recounted substantially similar observations from the crime scene and their discussions with defendant. In addition to a more detailed retelling of defendant's statements to police on November 21, the prosecution also presented the DNA evidence matching defendant to the DNA collected from the murder weapon. The grand jury indicted defendant on one count of murder in the second degree, Penal Law Section 125.25(1). Defendant moved to dismiss the second indictment pursuant to CPL 40.402, arguing that possession of the firearm found at the scene and used to commit the murder was joinable with the murder charge. County Court granted the motion. The Appellate Division reversed County Court and denied defendant's motion, reinstated the indictment, and remitted the matter to County Court for further proceedings on the indictment. The Appellate Division concluded that the conduct related to possession of the firearms and that related to the murder involved separate and distinct criminal acts that were not part of the same criminal transaction, and therefore CPL 40.42 did not bar the murder prosecution, citing People v. Brown. One justice dissented and granted defendant leave to appeal. 2A. Defendant contends that County Court properly dismissed the murder indictment under CPL 40.42 and, as relevant here, argues that the charges were part of the same criminal transaction because there was no break in possession between her use of the weapon in the murder on November 20, 2021, and her possession of the weapon the next day, November 21. The prosecution responds that the passage of time between defendant's completion of the homicide on November 20 and her subsequent apprehension on November 21 while in possession of the firearm used to commit the offense separates the criminal acts into different criminal incidents, allowing separate prosecution of the possession and the murder charges. The prosecution has the better argument. We conclude that the Appellate Division properly denied defendant's motion to dismiss and reinstated the murder indictment. The legislature, dissatisfied with the federal formulation of double jeopardy, adopted in the criminal procedure law what is generally known as the same criminal transaction test, which, in its purest form, prohibits a second prosecution based on the same transaction as a former one. Abraham v. Justices of New York Supreme Court of Bronx County, citing Ash v. Swenson, Brennan J. concurring. CPL 40.40 provides, in part, that where two or more offenses are joinable in a single accusatory instrument against a person by reason of being based upon the same criminal transaction, that person may not be separately prosecuted for these offenses if the prosecution is in possession of evidence legally sufficient to support a conviction for the uncharged offense, and either a trial of the existing charge has commenced or the existing charge is disposed of by a guilty plea, CPL 40.40(1)(2). CPL 40.41 incorporates by reference CPL 200.20(2)(a), which in turn incorporates CPL 40.10's definition of criminal transaction. Specifically, CPL 40.10(2)(a) provides that a criminal transaction means conduct which establishes at least one offense and which is comprised of two or more, or a group of acts so closely related and connected in point of time and circumstance of commission as to constitute a single criminal incident. See also Black's Law Dictionary, incident, defining incident as a discrete occurrence or happening. The court has explained that an act is a bodily movement, Penal Law, Section 15.001, while conduct normally consists simply of an act or omission and its accompanying mental state, Penal Law, Section 15.04, People v. Duggins. Further, CPL 40.10(2)(a) involves consideration of the nature, timing, and circumstances of the offenses. See People v. Lynch. At its core, CPL 40.40's same criminal transaction test prohibits a separate prosecution of joinable offenses that arise out of the same transaction and involve different and distinct elements under circumstances wherein no violation of the double jeopardy principle can validly be maintained, but the equities nevertheless seem to preclude separate prosecutions. People v. De Prospero. CPL 40.40's bar is squarely aimed at avoiding vexatious multiple prosecutions and promoting justice, economy, and convenience in criminal adjudications. People v. Ruzas, quoting Ash. B. The question in this appeal is whether the offenses of simple possession of the revolver on November 21 and murder with the revolver on November 20 constitute the same criminal transaction, because defendants' underlying acts were so closely related and connected in point of time and circumstances of commission as to constitute a single incident, CPL 40.10(2)(a). The relevant firearm accession charge arose from defendant's possession of the revolver on or about November 21, 2021, the day after the murder of defendant's grandmother. This charge was for simple possession, a class of possession offenses distinct from those based on possession with intent to use. Compare Penal Law Sections 265.01, 265.01b, 1, 265.02 with 265.3, 265.4, As we explained in People v. Billups, which was decided after the Appellate Division's disposition of the instant appeal, in cases of simple possession, the actus reus of possession is complete when a defendant exercises dominion and control over the firearm and is thus independent of any criminal use, such as shooting at another person. See People v. Billups. Billups involved a defendant who had obtained a firearm more than 1 hour before a robbery, carried it across approximately 15 city blocks, and briefly stashed the weapon in a co-conspirator's apartment while continuing to plan the robbery, and then ultimately wielded the weapon during the underlying crimes. We assessed whether the simple possession charge could be sentenced consecutively to concurrent robbery and felony murder charges despite the overlapping elements between those offenses. although Billups involved consecutive sentencing under Penal Law 70.25, and here we are concerned with the CPL 40.402, prohibition on multiple prosecutions for various offenses arising from the same criminal transaction. Billups is nonetheless instructive as to whether the point in time and circumstances of commission of the possessory offense are closely related to the substantive crime, CPL 40.10(2)A. In Billups, we concluded that in the context of convictions for simple possession and a crime involving use of that weapon, evaluating whether a defendant's acts were separate and distinct for consecutive sentencing purposes requires a different analytical approach due to the heightened level of integration between the possession and the ensuing substantive crime for which the weapon was used, quoting People v. Wright. While the act of possession has been described in some contexts as, by its nature, continuous, right, Billups clarified that the act of simple possession generally does not merge with a subsequent crime involving use of the weapon, because the actus reus of possession is complete when a defendant exercises dominion and control over the firearm. Billups, citing People v. Brown. Because CPL 40.10(2)A analyzes the circumstances of commission of an act or group of acts, and the temporal proximity between those acts is crucial to understanding whether they constitute a single criminal incident, Duggins, Billups's analysis of simple weapons possession also informs the meaning of criminal transaction for purposes of CPL 40.40 in cases involving separate indictments charging simple possession and a crime involving use of that weapon. The grand jury indicted defendant on simple possession charges, which required actual, physical possession of the firearms or dominion and control over the location where they were discovered on November 21, irrespective of their use in a separate crime. See People v. Manini, defining constructive possession. Consequently, the differing elements and the circumstances of the commission of these offenses show that defendant's simple possession of the revolver was not part of the same criminal transaction as the murder charge. The possession could have been completed months in advance or on the day after the murder, because the charges defendant pleaded guilty to were possession of the firearms on or about November 21, attaching the possession charges to the moment in time when the officers discovered the illegal firearms and not the moment of the fatal shooting. See Penal Law Section 265.01-B1. A person is guilty of criminal possession of a firearm when they possess any firearm. Moreover, the prosecution explicitly charged the grand jury on both physical and constructive possession, meaning defendant was only required to have dominion and control over the area where the firearm was located, and further explained that the firearm need not be loaded, but it must be operable, and that defendant is required to know that they are in possession of a firearm, but is not required to know that it was operable. All of the evidence presented to the grand jury was intended to establish the acts underlying the simple possession offenses. The prosecution did not press the narrative of the murder crime at the first indictment and did not argue that defendant should be charged with possession because she shot her grandmother. Indeed, because defendant did not obtain the firearm for the purpose of using it in the murder, the two crimes are not unified by a common criminal purpose. Defendant argues that her claim fits within precedent, holding that a defendant's possessory act and substantive crime were part of a single continuum of action. Her argument fails because the simple possession was completed independently and unrelatedly to the acts connected to the homicide. The fact that defendant committed the murder with that same weapon does not alone show that these acts were part of the same criminal transaction. Therefore, contrary to the dissent's view, the discovery of the illegal firearms alongside the homicide is not sufficient to tie these offenses together as a single criminal transaction. This is not a case, for example, where defendant possessed the same gun on the same day in different locations and was charged in different indictments with simple possession, treating each location as a separate offense in clear violation of the successive prosecution bar, cf. Matter of Johnson v. Morgenthau, holding that the prosecution's allegations that the defendant's uninterrupted 6-day possession of the same handgun across 2 counties rendered the possession a single continuing offense, thus barring successive prosecutions for third-degree weapon possession in each county. Neither was there any attempt by the prosecution to divide a single crime into a series temporal or spatial units. 3. The dissent unpersuasively claims that our decision will encourage the type of prosecutorial misconduct CPL 40.40 was designed to address. First, the dissent asserts that we have adopted a categorical rule that simple possession charges are never part of the same criminal transaction as a substantive crime relevant to those charges. We adopt no such rule. Notwithstanding the heightened level of integration between the possession and the ensuing substantive crime for which the weapon was used, quoting People v. Wright, it is possible that in certain cases, simple possession could form part of the same criminal transaction as a substantive crime, including where the simple possession and the substantive offense occurred virtually simultaneously, see e.g. Billups, where weapon possession and robbery charges arose from one distinct act, e.g. the defendant's seizure of a police officer's gun, or where someone handed the defendant a gun just before they shot the victim, i.e., where the act of possession was simultaneous with the shooting, citing People v. Sturkey and People v. Brown. Here, defendant's own statements to detectives confirmed that she had possession of the firearms well before the homicide. Whether the prosecution has violated CPL 40.40's bar on vexatious prosecutions turns on the particular circumstances of the case, and here there is no evidence that separate indictments were filed to harass defendant. Second, the dissent claims that our decision incentivizes prosecutors to always bring a charge of simple possession rather than a charge of criminal possession with intent to use, and to stack those offenses. Our disavowal of any per se rule undercuts this argument. The dissent assumes that the prosecution would risk dismissal of the second indictment pursuant to CPL 40.40 and the charges alleged therein, no matter how serious, including, as here, murder, on the assumption that the court will automatically deny the defendant's motion. The assumption is unwarranted, given that there are external forces that incentivize expeditious investigations and prosecutions, including concerns for public safety and established constitutional prescriptions. As to the latter, defendant did not argue that the pre-indictment delay violated her constitutional rights to prompt prosecution. See People v. Singer, holding that unreasonable pre-indictment delay may constitute a denial of due process under the state constitution, and where delay is protracted, the burden shifts to the prosecution to establish good cause. Lastly, we disagree with the dissent's suggestion that the prosecution acted in an untoward manner. Murder is a serious offense, and murder investigations often take time and the expenditure of vast resources. Defendant's appeal is a good example of why a prosecutor may choose to proceed with a simple possession charge first, while law enforcement continues with its murder investigation. Defendant exhibited troubling behavior, and the circumstantial evidence pointed to her as the shooter. Neighbors and family members corroborated that defendant had a history of mental health issues, and her statements to the homicide detectives vacillated between confessions of guilt and claims that another family member had killed her grandmother. The prosecution may have determined that, under the circumstances, it was best to proceed on the firearm possession charges given the clear evidence in support of those charges while continuing to investigate the murder. Nor is this a case where defendant was lulled into believing her plea to simple possession would end the matter. Defendant exercised her statutory right under CPL 220.10(2) to plead guilty in full satisfaction of the simple possession indictment. In other words, it was defendant, not the prosecution, who drove the procedural posture of the case. When defendant pleaded guilty, the prosecution, defense counsel, the court, and defendant herself were all aware that a murder charge might be forthcoming, and the court confirmed during the plea allocution that defendant was aware of that possibility and that her statements at the plea might be used against her. By pleading guilty to the entire indictment, defendant effectively terminated the first prosecution unilaterally, triggering her ability to file a motion to dismiss under CPL 40.40. The prosecution was not free to dictate whether, when, or how defendant entered her plea, nor even whether they could file a superseding indictment adding the murder charge under CPL 200.80. And any double jeopardy consequences flowing from the sequencing of these proceedings are therefore attributable to defendant's own exercise of that right, not to any prosecutorial overreach. Plainly, there is no indication that the separate prosecutions here, with the simple possession charges disposed of by defendant's plea before a grand jury separately indicted her on murder, were an attempt at gamesmanship by the prosecution. These simply are not the paradigmatic, vexatious multiple prosecutions that CPL 40.40 is intended to prevent. Accordingly, the order of the Appellate Division should be affirmed. Order affirmed. Opinion by Judge Rivera. Judges Garcia, Singas, Canataro, and Holligan concur. Chief Judge Wilson dissents in an opinion, in which Judge Troutman concurs. Decided May 26, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.